So, ladies and gentlemen, a very warm welcome to the 2011 Eddie Koiki Mabo Lecture. This is the first time that we've run the Mabo Lecture from Cairns, and because of the significance of the event, we're linking up with Townsville, Mackay, Mount Isa, Thursday Island and Singapore. So welcome everybody by video link. So my name is Nola Alloway and I'm the Pro-Vice-Chancellor of the Faculty of Arts, Education and Social Sciences that incorporates the School of Indigenous Australian Studies. To begin this evening, I would like to acknowledge the traditional custodians of the land on which we meet and to pay my respects to their elders, both past and present. But more importantly, I would like to introduce to you Jeanette Singleton, an elder of the Irukandji tribe, who will offer us a welcome to her country.
Good evening. First of all, to a friend, Mr. Mick Gooda, the Aboriginal and Torres Strait Islander Social Justice Commissioner. Ladies and gentlemen, on behalf of the Irukandji people, I'd like to welcome you all here to James Cook Uni for the lecture of Eddie Koiki Mabo, 2011. So I welcome you here to James Cook Uni, which is smack bang in the middle of our traditional country. Our country goes from Trinity and left north, even including Port Douglas. We are the people on the coast. In fact, a bit of history about ourselves. My great-grandfather Billy was a boy of 7. He lived most of his life on the Cairns of the Esplanade in his gunya. He was a boy of 7 when the settlers came looking for a port, when they came looking from the tableland to shift out whatever minerals they had up at the top. And he lived most of his traditional life on the Esplanade, going up and down and even up on the tablelands, going as far as Veranda, I guess. And he was given 2 king plate, one in 1898, 4 years before this country became a federation. And we located that breastplate. It was over in North Dakota, and we brought it back a few years ago where we had a civic reception in Cairns City. And he was also given another one later on where all this politics now has been played in Cairns City. The second breastplate was down where the casino is. There was an old custom house there where they got my grandfather Billy from down on the Cairns Esplanade, took him there, Empire Day, and also another Aboriginal man called Uni, and they gave him a breastplate, King of Cairns. Well, looking back and doing the research, it was quite clear Cairns was first established on the Barron River, on the Barron Delta, and then it just expanded to the inlet. So when I look at it today, I would say the white man split out my country and gave it to another black group. And that's the politics that is played in Cairns City. And so that is one, something that we haven't forgotten, and yes, we haven't forgotten it because we know who we are and where we come from, and it's only a matter of time before we get the recognition that we are seeking. So it's a pleasure to welcome you here tonight for this is native title issues, and I think Eddie Mabo, that's what he is well known for. And thank you, Mick. Up to you.
All right, thank you. And so now to the Eddie Koiki Mabo Lecture. Eddie Koiki Mabo, the man in whose honour this lecture is held, had an important link with James Cook University. For those of you who don't know, Eddie was originally employed as a gardener at the Townsville campus of James Cook University, but apart from taking care of the grounds, it soon became obvious that Eddie had a thirst for knowledge as he became more involved in the university, sitting in on lectures and regularly visiting the library. Eddie's decision to pursue land rights through the courts was taken while he was at James Cook University. He wasn't alone. His great resolve to pursue this action was bolstered by the support he received from both staff and students alike. The Mabo Lecture has been held annually since 2004 in recognition of Eddie Mabo's quest to have traditional land ownership recognised in Australia and in acknowledgement of his association with James Cook University. Each year, the lecture is presented by a person who has made a significant contribution to Australian life. And this year, that person is Mr. Mick Gooda. Now, Mick, actually, I had a little bit written about Mick here, and he just put a line through some of it and said, not all of that. So I'll just tell you a couple of things. Mick Gooda is the Aboriginal and Torres Strait Islander Social Justice Commissioner, and he is a descendant of the Gangaloo people of central Queensland. He has over 25 years' experience in leading service programs and organisational reform. Mr. Gooda was previously the Chief Executive Officer of the Cooperative Research Centre for Aboriginal Health. His work within the organisation placed Aboriginal and Torres Strait Islander people front and centre in the research agenda in areas such as chronic disease management, skin infections, and promotion of cultural change in hospitals to make them more appropriate to meet the needs of Aboriginal and Torres Strait Islander people. Mr. Gooda has been actively involved in advocacy for Indigenous affairs throughout Australia and has delivered strategic and sustainable results in rural, remote and urban environments. And that's all I'm allowed to tell you. So before I move over to Mick, could I just say that in terms of the format for this evening, there's going to be about a 30-minute presentation by Mick and then 30 minutes for a Q&A session. Could I ask you too, as a courtesy to our speaker, that you turn your phone on silent? It's really distracting if you're in the middle of a thought and the phones start ringing. So with that, could I invite Mr. Gooda to come to the podium? Thank you.
Thank you, Nola, for that lovely introduction. I had to cut things out because I get a bit embarrassed, about what people have written about me. So I did indeed put the line through a few paragraphs that she had there. But I need to begin by acknowledging Jeanette and the Irukandji people, the traditional owners of the place upon which we sit and talk here tonight. I honour your elders that have come before us, those that are here tonight, and I await in an optimistic anticipation of those elders who are yet to emerge. My people are the Gangaloo from the Dawson Valley in central Queensland. Jeanette, I stand here proud to bring a message from my elders. First, they asked me to pass on their greetings and their thanks for allowing me to be here tonight. And then they say that they are aware of your continued fight for your culture and your country and salute you for that ongoing struggle. I think it's an honour for both my people, the Gangaloo, and for me to be presenting this year's Eddie Koiki Mabo Lecture. I'd like to thank James Cook University and Professor Nola Alloway from the Faculty of Arts, Education and Social Science for the invitation to speak here. I also acknowledge all of my brothers and sisters in the audience, lots of whom who I've worked with. Can I also acknowledge my non-Indigenous friends and people I don't know, because you make our world so interesting. I also need to acknowledge Eddie's daughter Gail, who was going to be here tonight representing the Mabo family. And I really needed to say I'm acutely aware of the strains and stresses that the families of our heroes, such as Eddie, endure when fighting the good fight for our people's rights. Aboriginal and Torres Strait Islander people across the country also owe a debt of gratitude for the sacrifices that Mrs. Mabo, Gail's brothers and sisters, also endured during this struggle. Eddie Koiki Mabo, David Passy and James Rice, on behalf of the Meriam people of the Murray Islands and the Torres Straits, showed tremendous leadership to challenge the Queensland Government and the High Court. As we all know, the outcome of this challenge was the High Court's rejection of the common law doctrine of, or as I'm sure Eddie would have said, the lie of terra nullius. Without this legacy of the High Court's decision on native title, there would be no opportunity for us to access this unique form of land tenure that recognises our native title rights and interests to our traditional lands and waters. I remember working in the Torres Straits in the late 80s when a buzz would go around Thursday Island letting us know that Koiki was back in town. On one occasion, a couple of us decided to go down the courthouse to see what all the fuss was about. After sitting there for a couple of hours, trying to make out we understood what was going on, as the lawyers argued points of law back and forth, we decided it was all a bit boring and went back to work to do more exciting things like acquitting grants or checking up on CDP participant schedules. I was also in Thursday Island when a famous boat in Queensland, the Belvedere, took those involved in the final hearings around the Straits and finally to Murray Island. When it returned to TI, I remember my friend Lloydie Mazza, a Murray Island man, entertaining lawyers, court reporters and even the boat crew, regaling them about the part they were playing in what would be one of the most important decisions in the history of this country. I'm not sure whether we all shared Lloydie's optimism, but in 1992, when I heard the decisions, my thoughts went to the joy and elation that Lloyd would be feeling. But then I had to have a touch of sadness because sadly, Eddie never got to see the results of his efforts and those of James and David. And it's those efforts that we honour here tonight. Before I get into my presentation proper, I think I need to give you some background about my role as Aboriginal and Torres Strait Islander Social Justice Commissioner. The role is defined in both the Australian Human Rights and the Native Title Acts, and my duties include the preparation of 2 annual reports. The first one, the Native Title Report, which reviews the impact of the Native Title Act on the exercise and enjoyment of human rights by Aboriginal and Torres Strait Islander peoples. I also do a social justice report, which reports on the issues also affecting the human rights of Aboriginal and Torres Strait Islander more generally, but in accordance with the Australian Human Rights Commission Act. In the Native Title Report 2010, I outlined the key priorities for my 5-year term. These are to advance the full implementation of the United Nations Declaration on the Rights of Indigenous People in Australia, to promote the development of stronger and deeper relationship at 3 levels. First of all, between Aboriginal and Torres Strait Islander people and the broader Australian community, between Aboriginal and Torres Strait Islander people and governments. But the thing I want to talk about tonight, between Aboriginal and Torres Strait Islander peoples ourselves. I also set out the themes in native title that I want to focus on in this time. These are building an understanding of and respect for our rights to our lands, territories and resources throughout Australia, creating a just and fair native title system through law and policy reform, promoting effective engagement between governments and Aboriginal and Torres Strait Islander peoples, enhancing our capacity to realise our social, cultural and economic development aspirations. I believe these key areas of relationships are embedded and derived from the Human Rights Agenda and that United Nations Declaration on the Rights of Indigenous Peoples. This year's Native Title Report will be tabled in Parliament and launched late next month. So I thought when I was developing my thoughts around this presentation that I would take this opportunity to share with you the theme and some of the issues I will discuss this year. I used both the Native Title and Social Justice reports in 2011 to start a conversation about lateral violence and the ways in which Aboriginal and Torres Strait Islander people can create foundations to strengthen and rebuild our relationships within our families, our communities and in our organisations. For those of you who are wondering what I mean by lateral violence, let me explain. Lateral violence comes from behaviours that might include bullying, gossiping, jealousy, shaming, social exclusion, family feuding organisational conflict, which often escalates into physical violence. Now, lateral violence occurs at all levels of society, but for oppressed people, it is particularly acute and has a particular sharp edge. The theory behind why lateral violence impacts on us so differently is because it is often the result of disadvantage, discrimination and oppression, and it arises from working within a society that is not designed for our way of doing things. For us, lateral violence can be described as internalised colonialism, and according to Richard Franklin, includes the organised harmful behaviours that we do to each other, collectively and as part of an oppressed group. When we are consistently oppressed, we live with great fear and great anger, and we often turn on those who are closest to us. The concept of lateral violence for oppressed groups of peoples has its origins in the writings on colonialism from Africa and Latin America, as well as in the literature around the oppression of African Americans, Jewish people and women. According to this literature, lateral violence is created by situations of power imbalance, which in turn affects the identity of the people who are colonised. This occurs because colonised groups internalise the values and behaviours of the oppressors, which leads to a negative view of themselves and their culture. Anger and frustration about the injustice of feeling powerless manifests itself in violence, not vertically towards the oppressors responsible for the colonisation, but laterally towards their own community. Acts of lateral violence establishes new hierarchies of powers within colonised groups that mimic those of the colonisers. So not only are we dealing with the harm that lateral violence causes individuals, we are also dealing with the destruction it causes to our traditional structures and our roles in society. Our history of colonisation here in Australia describes a similar story. Aboriginal and Torres Strait Islander peoples have been living on our lands with the environment up to 70,000 years. We have strong social structures, sophisticated systems of law, a rich culture and complex ways of living, surviving and thriving in our sometimes harsh landscape. We have mechanisms to govern not only our interpersonal relationships, but trade and territorial agreements and conflicts between different nations, clans and groups. Men and women's business, elders' councils and ceremonies regulated all aspects of life and were used in the main to resolve conflict. When the British arrived on our lands, rather than respect these laws and customs, the story of terra nullius was fabricated. Aboriginal and Torres Strait Islander peoples simply did not exist as fellow humans in the eyes of our colonisers. Similar to other colonised countries, Aboriginal and Torres Strait Islander people found there was no effective way for them to challenge the power and resources of the colonisers. And it is important to understand this history of colonisation and the resulting dispossession of our lands and waters is an ongoing experience for many of us right up to this present day. In reaching this understanding, we're able to recognise that non-Indigenous people continue to control the structures, processes and policies that provide access to wealth and power. This creates an environment where Aboriginal and Torres Strait Islander peoples are relatively powerless and lateral violence is able to thrive. So what's the association between lateral violence and native title? As I've said earlier, Eddie Koiki Mabo, David Passy and James Wright fought for and secured the High Court decision on native title, which recognised our connections to our lands and waters by creating a unique form of land tenure that attempts to intersect our traditional laws and customs with the Australian common law and legislation. The Native Title Act was then developed, which codifies a process that can lead up to the recognition of these relationships. Acknowledging our rights to and interests in our country has the potential to generate positive outcomes for our communities. But too often this potential is not realised, and lateral violence fragments our communities as we navigate our way through the native title system. I know of lots of communities where there are wounds that, in my view, will never heal because of what they had to go through to secure their native title. However, I need to emphasise that native title in and of itself does not necessarily cause lateral violence, nor is native title the only forum within which lateral violence plays out for Aboriginal and Torres Strait Islander peoples. Rather, lateral violence is created by experiences of powerlessness and oppression and can manifest in many different situations and many different communities. For instance, native title processes requires individuals and families to meet to describe and prove their connection to country, identify their ancestors and decide who will be the applicant. These meetings provide a forum which can add fuel to the fire in communities where feuds between individuals and families are already a source of conflict. Each of these issues can create and contribute to positions of power within our communities and in this way provide a catalyst for lateral violence. Native title process, therefore, can provide a platform for latent conflict to develop into lateral violence because families, communities and organisations have to meet to decide fundamental questions about their identity and where they fit within the native title claim group. These issues of power and questions about identity feed into the cycle of latent conflict and lateral violence. These questions of identity are fed by the inherent contradiction between past government policies that removed our people from our country and the current requirement under the Native Title Act for us to prove continuing connection to our land and waters since the arrival of the British. In this year's Native Title report, I set out the native title processes and explain how at each stage of the native title system, lateral violence can be generated. This is because of the long and resource-intensive native title process provokes issues of powerlessness and questions of our identity. I again want to emphasise that it is necessary to distinguish between native title outcomes that recognise our rights and interests in our land and the native title processes outlined in the Native Title Act. I now need to provide some answers because it's not all doom and doom. And as I said at the beginning of this lecture, I've committed to using the United Nations Declarations on the Rights of Indigenous Peoples to guide my work during the time in this position because it reaffirms that Indigenous peoples are entitled to all human rights recognised in international law without discrimination. But it also acknowledges that unless the collective rights of Indigenous peoples are recognised and our cultures are protected, we can never be truly free and equal. The Declaration is about creating new relationships between Indigenous peoples and governments based on partnership, mutual respect and honesty. I believe that it can also be used to guide the relationships within the Aboriginal and Torres Strait Islander community. This is because the rights set out in the Declaration can support us to maintain environments that are culturally safe for us to address the outcomes of this lateral violence epidemic. In my view, the Declaration is not only a guide, it is also an assessment tool against which communities and governments can measure the successful application of human rights standards as they apply to Aboriginal and Torres Strait Islander people. In addition to clearly outlining our human rights, the Declaration contains a number of key principles that underpin the rights contained within it. For me, these principles are self-determination, free, prior and informed consent, non-discrimination, and the maintenance and protection of culture. Self-determination, as it applies to Indigenous peoples, is the right of a group of peoples to meet the human needs of that group, including the means to preserve that group's identity and culture. Exercising our right of self-determination means we have the freedom to live well and live according to our values and our beliefs. Similar to the principle of self-determination, free, prior and informed consent reinforces all the rights contained within the Declaration. Indeed, free, prior and informed consent has been identified as a requirement, prerequisite and manifestation of the exercise of the right to self-determination. Discrimination arises where the powerful assert their authority against the powerless. While Aboriginal and Torres Strait Islander people can face all the categories of discrimination, including sex, age and disability, It is the race-based discrimination that exacerbates the effects of all the others. Finally, culture is a source of strength, resilience, happiness, identity and confidence for our communities. So to access our lands, territories and resources, it is essential to the maintenance and protection of our cultural identity, our cultural integrity and our cultural self-determination. As I've said earlier, these rights of self-determination, free, prior and informed consent, non-discrimination and the protection of our cultures and identities are contained within the Declaration. It is my view that lateral violence can occur when these fundamental human rights and principles are not met. I strongly believe if we draw on these principles in the Declaration to guide our efforts to secure the rights of Aboriginal and Torres Strait Islander peoples, the potential for lateral violence will be significantly reduced. So what are our options for addressing lateral violence in native title? I want to enlarge on 3 opportunities to progress legislative and policy reform that will respond to these recommendations and significantly improve the operation of the native title system. These are to ensure the unique and inherent rights of Aboriginal and Torres Strait Islander peoples are protected under the National Human Rights Framework. Reform the Australian Constitution to recognise Aboriginal and Torres Strait Islander peoples and prohibit discrimination on the basis of race. Maintain efforts aimed to create a just and equitable native title system. The establishment of the National Human Rights Framework provides all of us, Aboriginal and Torres Strait Islander peoples in governments, the opportunity to embed a regime that recognises and respects our inherent rights. Its development also provides the Australian Government with the perfect opportunity to work with Aboriginal and Torres Strait Islander peoples to review and, where necessary, reform all relevant legislation and policies to ensure their compliance with the human rights standards of the Declaration. This framework has 3 parts: a human rights in the public sector, so our public sector actually is aware of the human rights. Public awareness of human rights, so the public is aware of it. And with this, we're now starting to work with ACARA in developing the new curriculum. The establishment of a parliamentary committee to scrutinise proposed legislation for compatibility with Australia's international human rights obligations. My aim is to have this declaration entrenched in all 3 parts of this framework. Moving to constitutional reform, it's an issue that's close to my heart and something that I wrote about extensively in the Social Justice Report last year. Because Aboriginal and Torres Strait Islander people are not recognised in the Australian Constitution as our nation's first peoples. And as such, the Constitution offers no protection or recognition of our rights to our lands, territory or resources. The Attorney-General has referred to the Constitution as our nation's birth certificate, which sets out the legal and political framework upon which our nation is built. The current Chief Justice of the High Court has referred to it as defining our legal universe. While this is the case for most modern Australians, the Constitution fails to recognise that Australia is home to the oldest living cultures in the world and is something that each and every Australian should be proud of and be proud to assert as part of the Australian national identity. And indeed, if it is our birth certificate, it should reflect our place in the nation as first Australians. It should reflect the nation's complete genealogy, not just one part of the family tree. I believe these reforms to the Australian Constitution will go some way to stemming the ongoing impacts of colonisation and lateral violence. I think it will affirm our places as first peoples of Australia and recognise the untruth of terra nullius in our founding document, addressing the history of exclusion of Aboriginal and Torres Strait Islander peoples. Before 1967, we were excluded from being counted in the national census, and the Commonwealth was excluded from making laws on our behalf. I think it will also improve the sense of self-worth and social and emotional well-being of our people as individuals, as communities, and as part of the national identity. It will also change the context in which debates about the challenges faced by Aboriginal and Torres Strait Islander peoples take place. And finally, I think it will be the last plank in settling this relationship between Aboriginal and Torres Strait Islander peoples and the rest of the Australian community. I think we cannot let this opportunity go without addressing those parts of the Constitution that facilitate discrimination on the basis of race. The right to live free from discrimination is a fundamental human right that most Australians take for granted. This year, the first formal steps towards a referendum began with the establishment of the expert panel on constitutional recognition of Indigenous Australians. This panel, of which I'm a part, is charged with leading the broad national consultation and community engagement program to seek the views of Aboriginal and Torres Strait Islander peoples and non-Indigenous peoples. It will report to the Australian Government in December on the options for constitutional recognition of Aboriginal and Torres Strait Islander peoples. The issues we are currently discussing, and we meet later or earlier next month, include a statement of recognition in the preamble to the Constitution or in its body acknowledging Indigenous Australians' distinct culture, identity and heritage, our prior ownership of our land and our ongoing contribution to Australian society. The inclusion of a statement of values in a preamble or in the Constitution itself, which would include both the recognition of Indigenous peoples but also send out the fundamental values of our society, such as our personal freedoms, the rule of law, racial and gender equality, and our commitment to democratic government. The repeal or amendment of those sections of the Constitution that currently facilitate racial discrimination, namely Section 25 and Section 51-26. The creation in the Constitution of a new guarantee of non-discrimination and racial equality, and new powers for the Australian Government to legislate to protect Indigenous culture, heritage and to redress historical disadvantage. It's my view that we'll be voting in a referendum sometime before the next election, which is due in 2013. But to those who doubt the importance of what amounts to a form of words, I say this. This process will give this generation of Australians the opportunity to say yes, an opportunity to demonstrate the goodwill and innate decency just like 90% of Australians did in 1967. This is an opportunity we cannot afford to lose. I want to talk a bit about native title reform because this is where some of our main problems lie. Like I said before, establishing our claims to native title involves extensive requirements for proving our identity and connection to country. In the shadow of this dispossession, it is often the questions of who we are that can exacerbate lateral violence in our communities. The native title reforms that I and previous social justice commissioners have advocated go some way to addressing these issues. These include improving the recognition of traditional ownership, minimising the current burden of proving native title, and addressing the operation of the law regarding extinguishment, and developing options for advancing negotiated settlements, including the potential for alternative comprehensive agreements. I'm of the view that these native title reforms would have a positive effect on addressing lateral violence in our communities. The reforms may be of particular benefit, include reversing the onus of proof, providing more flexible approaches to connection evidence, and exploring options for negotiating those alternative agreements. In this year's Native Title report, I call for a review of the Native Title Act to bring it in line with international human rights standards. This should incorporate our collective goal to a fair, independent, impartial, open and transparent process that acknowledges our traditional laws and customs to our lands, territories and resources, and eases the burden that comes with the requirements to prove our identity and connection to country. However, while I think we can talk extensively about the systems and things that like colonisation and how that impacts on us, the main responsibility for addressing lateral violence lies with us. I'll outline a couple of options. I think the first step towards exerting control over an issue is giving it a name. It is a way of exercising agency and responsibility for our communities. Naming lateral violence in itself becomes an action of prevention. We know that the conversation around lateral violence is not going to be an easy one. It means confronting those in our communities who perpetrate lateral violence and holding them accountable for their actions. But facing up to tough issues is not new for the Aboriginal and Torres Strait Islander community. There are many instances of communities confronting problems like family violence or alcohol abuse with great courage. Naming lateral violence is essentially a process of awareness raising and education. It's about giving communities the language to name laterally violent behaviour, the space to discuss its impact, and the tools to start developing solutions. One part of lateral violence is bullying. It has a pervasive effect in many areas of life. In our world, bullying has become one of the weapons of choice in lateral violence. Just as the wider society is now confronting the insidious effect of bullying, so must we. One of the growth areas of bullying is in the cyber world, where perpetrators can remain anonymous and there is no need to ever do anything face-to-face if they so wish. But as anyone knows who has been confronted by this form of lateral violence, the effects can be absolutely devastating. Like I say above about naming lateral violence, so it is with bullying. Calling it when it is perpetrated is the first step in making it stop. We need to have environments in our communities, families and organisations where everyone can feel safe and secure. However, to do this, we need to forge strong partnerships with the communities and other organisations involved. In my social justice report this year, I talk about the case of cyberbullying in Yuendamu, where we've seen collaboration between community groups, police and the Department of Justice to address this awful occurrence. Dispute resolution is so important. I discussed earlier how the process of colonisation undermined our traditional ways of resolving conflicts based on our complex customary laws. When thinking about lateral violence, it's important never to lose the sight of the fact that we've been here nearly 70,000 years before the Europeans arrived. This fact makes me confident that we can once again enjoy a life where conflict is properly managed and lateral violence does not rule our communities. And we can't forget the effects of lateral violence on our social emotional well-being. Some of the most serious impacts of lateral violence can be found how it affects that social emotional well-being. At its most tragic extreme is the high level of suicide and suicide attempts in our communities compared with the non-Indigenous community. Addressing lateral violence requires healing approaches. Many of these sorts of programs can help the healing of the harm caused by lateral violence and can also challenge the negative stereotypes, making our culture strong and safe enough to prevent lateral violence. The Family Empowerment Program in Yarrabah is a great example of a community-generated program that focuses on the healing needs of its participants. Although it was not set up explicitly to address lateral violence, by empowering themselves, building conflict resolution skills, dealing with trauma, grief and loss, and promoting a strong culture, it attacks lateral violence on a number of fronts. Now, in raising this issue of lateral violence, I say in this year's social justice report that I had to think long and hard about being open and honest about the damage lateral violence does in our communities. Am I contributing to the further demonisation of our people? While this is a view some people may possibly take, the damage and impact caused by not doing anything about lateral violence is, in my view, far greater than the risk of speaking out. But I've been buoyed by the positive reaction of people and their willingness to address this scourge confronting our communities. I've also been encouraged to keep on this path by the work being done around Australia by people like I said, David Baird at Giruni Yalamuka, who was instrumental in initiating the Family Empowerment Program in Yarrabah, Eileen Demal Hall from the Northern Territory Department of Justice, and Sergeant Tanya Mace in confronting cyberbullying in Yuendamu, and the work of Associate Professor Julie Coffin in her work with Yamaji communities families and schools in developing innovative ways to prevent bullying amongst young people in the Solid Kids, Solid Schools project. As I've said before, confronting lateral violence will take courage, foresight and leadership. But let me be clear tonight. We have been confronted by greater challenges, and the man who we gather here to honour tonight, Eddie Mabo, stands in the pantheon of our champions such as William Cooper, Udjuru Nunakal and Vincent Wangari, who were confronted by far greater challenges and prevailed. In conclusion, I highlight the need to ensure that legislative and policy frameworks advance Aboriginal and Torres Strait Islander peoples and empower us to reach our full potential in accordance with the Declaration on the Rights of Indigenous Peoples. The recognition of our native title provides a unique opportunity for many Aboriginal and Torres Strait Islander peoples to overcome disadvantage. But finally, I'll say again, the native title system must operate in a way that empowers us to achieve this outcome. It must be supported by strong foundations that ensure our self-determination and enable our effective participation in decision-making. By doing this, I think we do the ultimate honour to the efforts of Eddie, James and David in their fight for native title. Thank you, ladies and gentlemen.
Thank you. We're going to open the floor for question and answer. Okay, so we could start here. Any questions here? We could start in Townsville. Could you go to Townsville? Townsville? Right. Any questions from Townsville?
Come on.
Come on.
I dare you. I double dare you.
Is that turned on? It is.
That's even.
Is that somebody going to speak into a microphone? We can't hear you. We can't hear. I think people are trying to speak. Sandra, is that you in the front?
Signing. Is there anyone here?
Sorry, Townsville, we can't hear anything, but I just noticed, I think Sandra just got up and... Sandra, there you go. Now we've got Sue. Thank you, Sue.
I love this bit. Someone will be saying press F3. Should we ring someone and tell them?
Sorry, what about one of the other sites? Is that Mackay? I'm just going to switch over and see if we can go to Mackay.
Hello. No questions here from Mackay. Thank you.
A big crowd there.
Hello, can you hear us?
Yes?
Yeah, I can. Oh, I can hear you. Do you have a question?
Yeah, I've got to ask about my grandparents because that's a little more Northern Territory.
You want to come up to the one for that?
What do you want to get?
Yeah, the microphone's sitting on the chair.
Yep.
Yeah. Just a bit closer. Thank you.
Go ahead.
Yeah.
Anyway,
Can you hear us?
can you hear us?
Yep.
Hey, Mr. Good, I wanted to ask you a question about my about my mother and father. They come from the Northern Territory, but I found out that my father, my grandfather, and my great grandmother were all born on McArthur River State, where the miners are now. And I was trying to wonder why, I was entitled to any royalty money from that way.
No, I'm sorry, we weren't able to quite catch what you were saying. It sounds loud enough, but it's not clear enough. Do you want to have one more go at that?
Do you want to repeat the question?
If I?
Do you want to repeat the question? He hasn't heard you.
Hey, Mr. Gooda. This is Mr. Stratton and Mount Isa. I want to ask you a question about McArthur River, the Northern Territory.
Yeah, go ahead.
Can you hear me?
Yeah.
Yeah, my father, my grandfather, and my grandmother all come from McArthur River Station, where the miners are now. And I was told why I haven't get any royalty money from them.
It's kind of hard to hear that.
Yeah.
Oh, look, the McArthur River stuff, I know people like Mullandary up there trained across the floor to vote against it. I really can't answer that, why people aren't getting royalties for that mine. I understand the operation of the Native, not the Native Title Act, the Northern Territory Land Rights legislation actually has probably got the best regime of royalties in the country. So I can't understand why people wouldn't be getting. Is it people more generally, or is it your family not getting royalties?
I'm not too sure. I wouldn't know really.
No, sorry, we didn't catch what you were saying.
No, I said I didn't know, because I don't know much about the territory at all. Because I live in Queensland all my life.
We're hearing somebody sneeze, but we're finding it difficult just to decipher the words. Sorry, the sound isn't very clear, so we might just have to move on. Townsville, are we able to hear you? Okay, so someone could ring them on the phone. There you go.
You might need to take it off mute.
Do you want to ask the question? Do you want to ask the question?
I tried to bring you over before, which is
Okay. Hi, I'm Casper.
Thank you. If everybody could just listen for a moment, we're going to...
Who's going to go?
Centre, down a bit. Down a bit more. Oh no, camera's going. Okay. On.
These are like people stuck on an island, you know.
Hit 90.
Take us off mute. Take us off mute.
Yeah.
Shall I do my question first?
Yeah.
Okay. There's more to the board.
All right, I'm going away.
Mute. Inter, can you go back up for the board?
Question. Keep on coming. Hang on.
So,
Grace.
and Jason's got one as well.
And Janine.
Oh, so we've got 3 questions coming.
Okay, thank you.
Hello. A question for Mick. Thanks for his presentation. And he mentioned before the Family Wellbeing Empowerment Program, and as he knows, we've been working on that for some time. But unfortunately, governments and funding bodies seem reluctant to provide any resources for that program. Has Mick got any idea about how he sees maybe the empowerment program being resourced in that way?
Which program's that, Eva?
Yeah. Can you hear me? Or
I think this goes to one of my pet's issues with government. They just don't listen. You look at my in the social justice report this year, I will talk extensively about cultural competence and how we can get a culturally competent workforce within government. And last year's social justice report, I spoke about what I call the engagement workforce. How do we actually get people who are culturally competent to work with us, who can take the messages? Now, Noel Pearson expressed it like this, and I really think it's a good way of doing it. And when I talked about the imbalance between power, I think he frames it absolutely correct. And it goes like this. The problem we have is 90%, people who hold 90% of the power have 10% of the knowledge. And the people who have 90% of the knowledge only have 10% of the power. And he went on further to say, it's about as good as it gets with me with people listening. And I can't even make this mob listen. I really think we've got to, I don't know, I don't want to incite anyone here, but I think the issue about rising up and telling them we've had enough. And when programs like this are working, because that family empowerment program, I actually know a fair bit about that because we supported it when I was in the CRC. It is a really important program. It's an important project. It's an important initiative. It was producing good results. And I think we've got to find ways to hold the government accountable to this. I really don't know what else we can do. I'm meeting with Jenny Macklin next week. And I've really got to ring around to people to say the message I want to give her more than anything is, why don't you listen? Why do you have a department that just doesn't listen? They seem to think I call it the Northern Territory disease. And when you look around the country, since not 2007 when the intervention was put in place in the Northern Territory, look at what happened. Did we ever hear about leasing of Aboriginal land outside? Talking to Percy Neal, the chairman of I talk about the principle of free, prior and informed consent, yet his community gets told if you don't sign leases over to us, you won't get any money. I'd like to know where the free part in that is. Yet this is a party that commits to the implementation of the Declaration. So I think we've got to hold them accountable, and it's positions like mine, I suppose, that's what I get tasked with for the 5 years that I'm in here. And I don't know what answers to give you, Yvonne, when I hear things like this about programs like this being cut. Except, I don't know what it is. Is it because we're urban blacks or we don't count? Or is it because people don't listen? Is it because people don't care? But, he was a program based on evidence, evaluated. The tools were built by some of the best researchers and economists in the country to measure the outcomes. And surely they can't be challenging those sort of the evidence that program was producing. So I don't know, Yvonne. I'm going to have a crack next week when I go and meet with her. We'll see what happens. I've got to say, though, I'm not confident much change will occur until we start telling them that they've got to listen to us. And I guess that's a good example of about what I was just exactly talking about, the powerlessness that we feel in the system, which only adds to the frustration and then adds to the lateral violence that occurs in our communities.
Graceland, were you there?
Yeah, hi Mick. Can you hear me? Graceland, Smallwood. Can you hear me? No?
Yep.
The question, it's not a question, but I said good luck when you meet with Jenny Macklin next week, because we're all very frustrated that they're continuing the intervention, as you know. But, and thanks for your presentation. And the thing that I wanted to just reaffirm with you, Mick, is that after the Mabo legislation, the 10-point plan was put in and was melted down or watered down to the Native Title Act. And in my 44 years of advocating for land rights and self-determination, I've never seen so much stress and lateral violence all around this country amongst families that the Native Title Act is doing to our people. In particular, when land councils who are funded by government are bringing in very junior anthropologists to divide and conquer the communities and tell people after 80 years of knowing who their grandparents and parents are and telling them that they've got no affiliation to that country. And I'm very concerned, not just what's happening in Townsville, but everywhere I go, families are saying the same thing about traditional owner groups, and it's causing a lot of trauma. And I just wondered if you'd like to make a comment on that, Mick, because yourself that gets around so much in the country has to be seeing all this trauma. And just to follow on what Yvonne's saying, all the programs that are culturally safe and culturally appropriate that's effective, the government is setting us up to fail by not funding anymore. And we're at a real crisis stage at the moment. And I wondered if you could make a comment on what I've been saying. Thank you.
Look, Grayson, I think the issue of identification, I raised it a couple of times, more than a couple of times in my presentation. It is the one thing that drives us crazy. You're right when you talk about anthropologists and historians. They become the keepers of all of our knowledge, and we hand it over to them. And, like that incident I mentioned during my presentation about a community, I won't name it, where wounds will never heal. And one of the reasons I say that is because we ended up in a court case, and this man was describing his connection to land. Like, my grandfather, my father's father told me this, and this is where we went hunting. And he was doing all the stuff until a lawyer from the government got up and said, that fellow you think is your father is not actually your father. He's your birth certificate. We've done some research. Now, can you think of a worse way to be told these connections in your family weren't the way it was? And it was all about springing a surprise. You see those law shows and court case shows where people spring a surprise that's going to do it. That's what happened there. And my estimation, like I said, there are wounds in that community that don't matter what we do about lateral violence will never be healed. And look, what we talk about with, this identity issue, I've got friends who work in the native title area and I say, Mick, I'm not saying you're not Gungaloo, But what I'm saying is we don't have the evidence to support you in a court of law. These are court cases we're having with people being cross-examined. You know, that goes to the heart of your identity. This old lady from Canada, Maggie Hodgson, who's a great leader over there, talked about it like soul murder. It murders our souls when people say to us, we know more than you do. You know, and I think this is what we've got to fix up, the identity. Now, funny enough, there's a way forward. And what's happening in Victoria? It's coming out of Victoria. Victoria government has changed the onus of proof. So it's not up to Aboriginal people to prove who they are. It's up to someone who... Aboriginal people down in Victoria will have to work it out. They'll have to work out, and they're working on this. How do we determine... We determine who's traditional owners for our area. And then once they do that, and come to a conclusion and agreement on that, it's up to someone else to disprove it. So I think there are ways of doing it, and I don't think it gets away from having some sort of system to prove who we are. But my argument is that at least it's our system that we're working with, not a government, not a court of law. Anyone ever been to a native title hearing? How many lawyers? I've been to native title hearings where they've got to put in extra chairs and tables just to get all the lawyers in there. You know? I tell you, Grayson, can I tell you a story? And I will name him, an old fella, he passed away recently, and he got into this court case. And he got in, his name was Jimmy Wharton, and he comes from southeast Queensland. And I love his response to the questions. What was your connection? Well, I come from here, and this is where I was born, and this is where my family come from. And the lawyer got a bit aggressive about this. So Jimmy just decided to say, now listen here, mate. I've been called a coon, an abo, a bung, enough in this town, and suddenly that's not good enough for you people? So you've got to confront it like Jimmy did, you know. So they excused him and thought, well, he's connected now. But that's the extremes it puts us through, and that's why I keep on saying, how many people here have been subjected or been around when people say you're not part of this mob? You can't prove your connection. You know? Happens with my mob down in Rockhampton. You know, not that's where we meet. Our land's a bit further west from Rockhampton, but the Gungaloo mob get down and say, oh, you're not so-and-so, you're not Gungaloo, you're from this other mob, you know. So it's this identity issue that we all use against each other, you know. Coconut, not a proper black fella, feeds into all that stuff. And I really feel for people who can't prove their connection for whatever reason. You know, so I think that question of identity and connection is what I talk about by lowering the burden of proof on that, and let's us set it. So I'm waiting with interest to see how it pans out in Victoria, because I think it's a really good example of what can be done when people get together and think about innovative ways of dealing with native title. But I'll put a caveat on it. Victorian people seem to do it a lot better than most of us, you know, so that even with the Liberal government down there, they're doing a lot better than people in states like Queensland.
Thank you. Grayson, was there somebody else after you?
Oh, hi, it's Michelle DeShong here in Townsville.
Oh, Michelle.
Hi, Mick, how are you going? Great presentation, thank you very much. Just wanted to ask you a quick question. We've heard a lot about lateral violence and, you know, that the behaviours stem from the oppression that a lot of our people have faced, but particularly for women, there's an extra level of oppression that's been faced as part of colonisation and even at the hands of other women in terms of Australian society. And the other thing I think that's very interesting is we often hear about human rights, but to me there's a little bit of a disconnect in terms of the conversation about the rights of women and ensuring that the elimination of discrimination against women is upheld. What do you think are some of the mechanisms we need to be thinking about in Indigenous affairs to ensure the voices of women are heard and are acknowledged in such an important subject as this?
Is that Indigenous women? Oh, look, I think we've got to think about human rights like this. Without the exercise of human rights, they are basically meaningless. So if they're just pieces of paper, they are meaningless. And there's two concepts around human rights that I like to think about. One is what we call the universality of human rights, a universal. You don't have to do anything to access human rights, to enjoy human rights. We enjoy human rights because we're part of the human race. So you don't have to have money, you don't have to be disadvantaged. So we all have human rights. So the universality of human rights is really important. The indivisibility of human rights is a concept that I must say, Michelle, messed with my head for a fair while, because that concept says all human rights are equal. There's no hierarchy of rights. But in the ideal world, there is no hierarchy of rights, because when you exercise a right, you've got to exercise it in a way that protects, that allows other people to enjoy similar rights. And the one that I like to talk about is alcohol, because it's fairly topical. So people say, I've got a human right. People ring me all the time and say, Mick, you've got to protect your human right to drink alcohol. And I say to them, well, if you can show me where that human right is, I will protect it. But I can guarantee you there's no human right to drink alcohol. What they get mixed up with is the right to goods and services without discrimination. So per se, I think they get mixed up a whole lot of things when Aboriginal people weren't allowed to drink alcohol. However, if people decide to access that particular right to goods and services without discrimination by drinking alcohol, I tell them the first duty you have is to ensure you behave in a way that people can enjoy the same right. So if you're in a hotel or a nightclub or even at a party, you've got to drink alcohol in a way so everyone else can enjoy drinking alcohol. So you can't bully, you can't be violent, you can't harass people. Then it goes further. Not only do you have to protect the rights of people to enjoy the same right, you've got to protect their rights to enjoy all other rights. For instance, the right to be safe and secure. And what I consider the most important human right we have, and that's the right to life. So when rights are taken away and people don't act like that, someone makes a decision to intervene. So in the ideal world, all human rights are equal, and we would protect the rights of women similarly. But if we don't have it, there are some remedies that we do have. There is the Sex Discrimination Act. And Michelle, one of the things we've got to come to grips with in the Commission is we have now 6 commissioners. We have a Race Discrimination Commissioner, we have a Sex Discrimination Commissioner, a Disabilities Commissioner, and an Age Commissioner. The other commissioner besides me is the Human Rights Commissioner, plus the President. She does 2 jobs, Catherine Branson. So particularly about women, Liz Broderick is the Sex Discrimination Commission. We've got to work out how do all of those issues, those commissioners deal with the issues involving Aboriginal and Torres Strait Islander peoples. And I don't think they should be just coming to me. Graham Innes and I, who's the Disabilities Commissioner, was up in Alice Springs a while back. And we were meeting with the medical service there. We were doing he was also Race Commissioner at that stage. We were doing some race stuff. He was told by Congress, the big medical service in Alice Springs, that the Alice Springs Hospital is like a war zone with amputations. They probably do more amputations in Alice Springs Hospital than just about anywhere else in Australia. And Graham says, why haven't I heard about this? There are laws to make sure people with disabilities get access to buildings, get houses that are accessible, renovate bathrooms so they can cope. Same as there are laws about Indigenous women. So I think, Michelle, I'd like to talk to people and say, Liz Broderick wants to do the Indigenous thing, but she's not going to barge in. She will be, if people want to talk to me about ideas about how Aboriginal and Torres Strait Islander women want to connect with Liz Broderick, let me know, because I think she'll be a great advocate. But she hasn't spoken out yet that much because she doesn't believe she has as a non-Indigenous woman has the right to do that. So I guess what we've got to find, Michelle, is a way of one, making sure rights and all that are protected and women get the exercise rights the same as men. But then we've got to work out how we access that protection of human rights, of women's rights that Liz Broderick is charged with. And should she only protect the rights of non-Indigenous women? Of course not. So I'd love some feedback about how we can do this. How we can do this across the whole three things: age, race, sex, and disabilities. How can we make sure people with disabilities, I get access to a lot of data as people would in the medical world, a number of people who have hearing problems in the Aboriginal and Torres Strait Island community. 40% of people in prison, they tell me, have those sort of disabilities. What are we doing about that? So I think that's what's confronting us at the moment. And like I said a couple of times, I'd love to get some feedback about how we deal with those particular issues of discrimination, where our mob have got to get the same level of access to those protections as everyone else.
Thank you. So, Townsend, would you get them up?
Hello, Mick. This is Janine Gertz in Townsville. I'm sorry, I think I might
This is really awkward. I feel like I can do it.
Sorry, can I go ahead with my question, or is Ken's?
What's happening?
Okay. It's Janine Getz here in Townsville. Thank you for your presentation. And of course, hello? Nola, can you hear me? Can everybody hear me? Or?
Can everybody hear? Yeah, I think we're right.
Okay, sorry. Thank you for your presentation, Mick. Of course, I endorse your comments about the framework for the way forward being within the Declaration of the Rights of Indigenous People. I guess within your presentation, you outlined a number of the social and emotional wellbeing impacts on community and individuals. I wondered if you would like to offer some more comment this evening about the impacts of lateral violence within organisations and perhaps its further flow-on impacts into service delivery. And the second part of that question is about whether your reports would go so far as to recommend some sort of report into from the Productivity Commission into the impacts of lateral violence and its effectiveness of policies and programs.
Look, I think lateral violence is the reason I raise lateral violence is I don't just enjoy beating our mob up, But if we don't do this sort of stuff, I don't know where we end up here. In my last job in the Cooperative Research Centre for Aboriginal Health, I reckon I could name 10 Aboriginal doctors who would say, I will not work for an Aboriginal organisation. I will not work for an Aboriginal medical service because of the bullying that goes on there. Now, imagine 10 of them leaving our world. And the problem with that is they can do it because they're going to have other options. So bullying in our organisations, like I went a couple of years ago, Janine, I went to this organisation, I won't even name the state because people might even recognise it. And it was a medical service, and I said, look, can you tell me about tell me about the staff here? And this bloke gets up and he said, well, we have 3 groups here in this organisation. I said, oh yeah, what are they? He says, well, Aboriginal people, non-Aboriginal people, and wannabe Aboriginal people. And I said, well, how do you decide that third group? Oh, we know. So these people in the same room, I'm sort of thinking this must be lateral violence central. I've got to the heart of this. And what they said to me later on was, we got talking about this and we figured they'd got to address that because one thing I didn't do and I don't think we should do in those days, even now, is tell people what to do about it. If they're not going to develop strategies and tools to deal with lateral violence themselves, it's no good me or anyone else going to tell them what to do. That just defeats the whole purpose. It just adds to the powerlessness. But they did tell me the story about, you want to see the treatment we get from our clients. They come in and abuse us. And what can we do about that? And I said, well, this isn't such a small town here, or not such a big town. So everyone knows each other's business. And don't you think that they know how you treat each other? And aren't you sort of giving people permission to come in and also add to that treatment? I never thought about it, never thought, well, we behave like this, why would our clients behave any differently? So they had to start thinking about how we relate to each other. So this is the challenge for us. Now, the one thing I'll say about, we've got to call it. Like when I do lateral violence, in my last job, I did lateral violence training, with not training people to be laterally violent, by the way. Would say, you've got to decide this. You've got to decide what you do here. And that's how we've got to approach this. What behaviours do you perpetrate or whatever that contribute, and what can you do personally about stopping it? Organisations can have all the rules in the world, and there are already rules, industrial relation rules around violence and bullying and harassment, aren't there? Everyone who works in an organisation will know you can be sacked for bullying people, you can be sacked for harassing people. So there's already some of that there, but unless people commit to behaving differently, I think we're going to keep on having this problem. And I raised those issues about we've been around for 70,000 years. In my case, I'm lucky that it was just across a neighbour of ours, I think it was Bidjara country, where they did a first dig that proved the occupation past 5,000 years. Archaeologist John Mulvaney did that. So we've been there 19,500 years. So let's think about that. That's been scientifically proven. I look at my family now and my extended family, and I think if they behave like that 19,500 years ago, I'm flat out thinking we would last another 100 years. I'm sure we would have killed each other. And that's why I think we have to go back to the way we resolve differences. I know we can't turn the clock back and do this stuff, but we've got to actually think about what did we do to make us last here 19,500 years? How did we resolve disputes? And it was a very sophisticated way of doing it. So I think this bullying and all of that happens in our community organisation, we've got to call it. That's going to take a lot of courage to do that, because some of our bullies are pretty scary people. I know a few, probably know a fair few. Look, I think you should come to us. I really think, Catherine Branson, who's a federal court judge, is very strong. You listen to her speak out about human rights abuses in the refugee area. She doesn't really care about what she takes on. And we were down in Senate estimates last week and copped a little bit for that. But we value our independence, and I really think, Pat, we've got to raise those issues. But, yeah. Oh, but can I say something about the system? And there's two incidences that I think where people will never help. And maybe the first one has. The death of Mr. Ward in WA. The system let him down. You know? And the death of those Torres Strait Island people up there in that boat, you know? The boss went out for lunch, dinner. He was allowed to leave the public service, never even suffered anything. But how many people died? 5? And it really frustrates me that the system, they blame the system. And remember we went through, you know, I've been part of this, our stuff we went through, let's not apportion blame. You know, we've got to fix the system. I reckon we should apportion blame. I'm into blame nowadays. And holding people accountable. I think that's where we've got to get to. Who refused to look after that boy? Who had the duty of care? You know, Mr. Ward, like the perverse thing that happened there was finally the government gets fined, but guess what? They pay the money out of one hand, it just goes into consolidated revenue, you know. So did the government suffer any loss? Why I was a little bit doubtful because the 2 people who were involved ended up getting fined. But did that company that did it lose their contract? No. You know, this is what I mean, we get to this blaming the system all the time without, you know, getting down to saying who's responsible here. And I think that's where we've got to go to. Anyway, I think people are getting a bit anxious.
Mick, just one more question from Townsville.
Sorry.
Hello?
We're going to close off now, and those of you who are happy
Hello?
in this audience, we're going to move outside where there are refreshments, so you can continue to talk to Mick for a little while. But before you go, could I ask you to join with me in thanking Mick for his very fine tribute to Eddie Koiki Mabo.